Well, till the princely state remained, even after independence, they were called Raj Pramukhs. Even after the federal units, namely the states.
Until the 1956 amendment.
56.
When the Raj Pramukhs were abolished and you had the governors.
Became the governors, not the princely state. This is not in Jammu and Kashmir. It is reverse, I'll show. But they say, I am not admitting that I'll accept the future constitution of India.
The only difference was that this constitutional history led to the ultimate integration in every sense of the other states like Kathiawar, Saurashtra, Baroda. They didn't follow the 370 route because for J&K, the constitution decided to go to 370. The other states, there was no provision like 370. They merged and they were integrated completely. They accepted list 1, they accepted list 3. They accepted the ultimate dominion powers, executive and legislature of the dominion of India.
I am just showing this with a view to make one point, that a stand which is now being taken and which has been taken, that we had a special feature and therefore we were given a special treatment, and therefore this provision is kind of a privilege given to us which can never be taken away. But I'm just trying to show that there were many similarly situated princely states. They had also put their conditions, but eventually they subsumed themselves with the Union of India because of the Act of State doctrine and because of Article 363 and Article 1. But
they came into the Indian Union as a volition.
Correct.
They joined voluntarily. I mean, we take it as voluntarily. It may have been a little bit of persuasion. It may have been whatever. Real politics, yes, obviously.
Are made.
Obviously, no difficulty. And that was probably the genius of Sardar Patel. There's no difficulty. Absolutely. There's no doubt about it. But the fact, however, remains that insofar as J&K is concerned, J&K bucked that trend. J&K went to the 370 route.
Yes, but why, how, and till what time? Right. That will come subsequent. And that's why, for me, as I said in the outset, connecting the dots would be necessary.
So the limited point which you are making at this stage is that the instruments of accession of various princely states contain certain reservations. Now we have seen in regard to taxation, in regard to land acquisition,
binding constitution,
not binding themselves to accepting a future constitution. So the IOAs at that point of these states were hedged with various conditions.
This is also,
but that was consistent with Section 6 of the Government of India Act, which was adopted by Section 9 of the Indian Independence Act. We gave this sop to the princely rulers that, look, you come here on your terms. We are not telling you today to come on our terms. You agree to the Indian Union, you make reservations, and we hope that by and by you will accept full integration into the Union, which they did.
But another point why I wish your lordships made aware of this development is, there was an argument that instrument of merger was a necessary attribute for a complete integration. Otherwise, we had kind of an internal sovereignty. The lordships would recall that Jammu and Kashmir never signed instrument of merger. Many states did not sign instrument of merger. From the date on which Constitution of India came into force and Article 1 came into force as an act of the state, they became integral part of Union of India. And how Jammu and Kashmir got separated, and how it was only for a temporary period, would succinctly come in subsequent.
Interesting, Mr. Solicitor, this Department of States which existed in the Ministry of Home Affairs post 1950, after the 7th Amendment, right, 1956.
238 was, yes.
So the Department of States must have been abolished post 1956. You will be still having records in the Ministry of Home Affairs?
I'm sorry, my instructions are officer sitting was the additional secretary in charge of Jammu Kashmir in MHA. He said that department technically still continues.
So Department of State still continues.
Still continues.
Now, do we have, I'm not sure whether this exercise can be done just for, we don't have to do it by a very detailed document, but just a tabulation. If we can have a list of the states and, we can have, say, Kathiawar, instrument of accession, supplementary instrument of accession, and merger agreement. which of the states came into the union with a merger agreement? Which of the states had no merger agreement at all and yet joined the union? I don't know whether that now at this point of time that record will be there. If you can try and record, if you can sort of.
Yes. To a large extent, white paper indicates what happened.
I don't know if you have that record. I mean, how many out of these 562 who actually joined the the Union of India actually executed merger agreements?
What happened?
What I meant was, how many of these states which joined the Union of India did not execute merger agreements? That will be a smaller group probably.
But possibly.
So, which will then perhaps give some support to your argument that the execution of a merger agreement was not quintessential to acceptance of ultimate sovereignty by India. And second, many states, many princely states, were subsumed with the Union of India even without a merger agreement. And various states, therefore, were subsumed in the Union of India only with an instrument of accession.
We'll do that exercise. Substantially, everything is there in the white paper. But if there is something else also,
all 562 states, not India, what happened was there were small little principalities, small nawabs. They were larger.
We were just, in fact, Brother Suryakant was giving us a little bit of backdrop about Punjab and Himachal.
To integration with larger states. And then the larger one signed the instrument of merger.
Right. But we were wondering, was it possible? Because, Mr. Sibal, what we want a little bit of just factual.
I have understood.
Factual clarity. That they may were there Indian states. We shouldn't call them princely states. Because as Mr. Sibal says, some of the small nawabs, some of the princes.
We will have to say princely states, because Indian state would mean those which were under the sovereignty or suzerainty of British India. That's how it has.
They were the governor's provinces.
That's right.
No, but we just want to know this.
We will, my lord, undertake.
To sort of repeat two things. Which were the states which accepted completely to be subsumed within the Union of India without merger agreements, and followed only the IOA course and straight came into the Union of India?
There is no such instance, with respect. The white paper, which is part of the record. White paper is issued by Sardar Patel.
I'll formulate. I have understood the question. Let me not.
You know, Mr. Shankar, I just thought since the Department of States exists even today, this is something. This will be. They might take a day or 2 days, but they will be able to do it.
It would be done.
The table here with the states which have not entered into a merger. Helping your point. Actually, if you want a list of states which have
What is the source? What is the source of your table?
It's from the white paper.
White paper. There are inaccuracies. I'll put it that way.
So there are states which did not accept the merger and yet became a part of the Indian Union.
State of Mysore, state of Saurashtra pre-independence, Madhya Bharat, Patiala and East Punjab.
This is
part from the white paper. There is a chart.
We will, my lord, let's not, my lord, deviate from it. I have, my lord, taken the point.
Your point is that there were other states, basically whether it was 2, 3, 4, 5, whatever. There were other states which did not sign the merger agreement.
Yes, there was nothing special which is being claimed.
That's your point.
And second, that merger was such a sine qua non, without which you can never be an integral part of India, either under Article 1 or otherwise, or your special status must continue. But please,
so in other words, Mr. Solicitor, to sort of paraphrase your submission, it's twofold. First, the expression of reservations in the instrument of accession was not unique to the instrument of accession which was executed by Maharaja Hari Singh.
I couldn't put it that
way. To the execution of a merger agreement was not a sine qua non to be absorbed or become a part of the Indian Union. It's a twofold. We got the point.
There is no statutory source of merger agreements, and they were only signed in some cases as a result of negotiations between some states and Dominion of India. It seems, but it's more because of binding the princely state not to go back from its word that they were signed. It doesn't have any statutory source like instrument of accession. The country is one integral whole. Its people, a single people, living under a single imperium derived from a single source. This is the heart and soul of Article.
There is also a reference in his speech of 25th of November 1949.
Yes, for last closing.
Last speech. He said that our constitution is unique. It is federal at the same time unitary.
It is, my lord, it will come, my lord, in the chronology.
This speech of Dr. Ambedkar also lays bare the distinction between a constituent assembly and parliament. At the bottom of that page.
Yes, but that was read by Mr. Sibal,
Yeah.
therefore I missed. But I can go to that.
No, that's right.
But my lord, this was not read. So I'm not repeating
Yes,
what was read. My lord.
absolutely.
That's the
Yes,
intention.
absolutely.
Then, my lord, 8849 is just an example how you retain your sovereignty. That is, my lord, Bhutan. Bhutan has a treaty with us. Contemporaneously signed, my lord, in 4750, my lord, that is 8849, where, my lord, in external affairs, India has suzerainty. We don't have sovereignty. You can yourself realize the anomaly of the state becoming part of India and at the same time not recognizing any of these provisions. And I'll show till 76, Article 21 was not applicable in a truncated way. Article 19, there was a sub-article added as it applied to Jammu and Kashmir that the reasonable restrictions would be those which will be prescribed by the legislature, meaning thereby the persons against whom citizens invoke Article 19 would decide what would be the reasonable restrictions. I'll come to that. All those other states have agreed to integrate themselves in that way and accept the constitution provided. Maulana Hasrat Mohani, why this discrimination, please? But just pausing here for a minute so that the debate doesn't get boring. Maulana Hasrat Mohani was an eminent Urdu lyricist of his time. And if all of us, most of us have heard, Chupke Chupke Raat Din Aansu Bahana Yaad Hai. That is by Maulana Hasrat Mohani. I don't want to sing it. I know my limitations and I'll spare all of you on the lightest. Then, but there are several good lyrics, good Urdu ghazals and nazams written by Maulana Hasrat Mohani. Yes, yes. The question is very important. That why are you discriminating from people of one state and people of other? And your lordships would be shocked when I show the discrimination. We have analyzed, my lord, how the provisions were selectively picked up, modified and applied to one state. And I'm not saying that my power is taken away or state's power is taken away. So far, the residents of Jammu and Kashmir were being deprived of what I will show to your lordship. Till 5th of August 2009.